Good evening, everyone, and welcome to today's program, The Fight for Full Equality Under the Law, Defending the 14th Amendment. I'm the Reverend Dr. Roland Stringfall. I'm the board president of Inclusive Justice. Because tonight's program is national, we recognize that there may be some in our audience who are unfamiliar with the work of Inclusive Justice and what our work entails. Inclusive Justice is Michigan's faith-based coalition of welcoming congregations. We are inclusive of all spiritual traditions with the goal of advocating for LGBTQI persons' acceptance with religious and spiritual communities. We also partner with like-minded organizations to advocate for the equitable treatment of all persons in local, state, and federal policies. You can visit our website at inclusivejustice.org to see our past programs and for our educational trainings. Tonight's program is very much in line with our mission and advocacy of Inclusive Justice. Today is the 153rd anniversary of the ratification of the 14th Amendment. The 14th Amendment to the United States Constitution, which was ratified in the year 1868, granted citizenship to all persons born or naturalized in the United States, including formerly enslaved people, and guaranteeing citizenship, equal protection under the law. The story of the 14th Amendment is partly history of the struggle for human rights in our country, including the rights of African Americans, women, and most recently, same-sex couples. The assault on voting rights is a direct challenge to the 14th Amendment. And this evening, we have assembled a panel of experts who will help us understand this threat and how we, as caring citizens, can protect this right, which is a bedrock to our democracy. I'm now going to turn the program over to my colleague and friend, the Reverend Joe Summers, who will be our moderator for tonight. The Reverend Joe Summers has been the pastor of the Episcopal Church of the Incarnation since 1987. Joe became a pastor because he was drawn to the vision of the beloved community, the community of those who work to see that all receive what they need to know and themselves are beloved. As a child growing up in an interracial parish in St. Louis, Missouri, during the era of segregation, he was profoundly influenced by the civil rights movement. As a young adult, he was particularly influenced by the work of Dorothy Day and Paulo Freire. In addition to Inclusive Justice, he is currently active working with these other organizations, such as the Interfaith Council for Peace and Justice, the Washtenaw chapter of the Poor People's Campaign, the Faith Leaders Forum, Friends of Restorative Justice, Citizens for Racial Equity of Washtenaw, and the Michigan Center for Youth Justice. And with that, I'm going to turn it over to Joe Summers.
Thank you so much, Roland. And so grateful to all of you who are here tonight. I just want to again thank Roland both for that warm welcome and for doing so much important work here in Michigan and around the country. Today, as Roland said, marks the 153rd anniversary of the ratification of the 14th Amendment, an amendment designed to improve our Constitution so that it better reflected the aspirations to create a nation where, to paraphrase the Declaration of Independence, all people are recognized as equal and having certain unalienable rights, including the rights to life, liberty, and the pursuit of happiness, and a government who is meant to help secure these rights. Now, if only creating a new society was as easy as amending its constitution. No, instead tonight we will hear about the struggle that has gone on to undermine this amendment and to narrow its scope and meaning. And part of why we're still needing to engage in this struggle is because while the language of human rights was partly developed as a way to mediate conflicts between Christians, between Protestants and Catholics, to make these conflicts less deadly, by creating a framework within which the dignity of all could be honored. So many of my religious sisters and brothers don't understand the vision of human rights as a way of honoring the fundamental dignity of all. So many fall prey to the divide and conquer strategy of those who would say we should recognize the human rights of some folks, but not others. But human rights are about everybody's rights on the basis of their simply being human, or they're not human rights. And history has shown us repeatedly that when we fail to fight for the rights of all, the power and the promise of the vision of human rights is lost. Tonight, we're honored to have an amazing group of speakers to help us think about these issues at this critical point in our nation's history. First, our keynote speaker is Roger Smith. Rogers is a professor of political science at the University of Pennsylvania. He was also one of the most recent presidents of the American Political Science Association. His research and writings focus in part on issues of citizenship and race and gender and class. He's the author of numerous books, including That Is Not Who We Are, Populism and Peoplehood, Political Peoplehood, The Role of Value, Interests, and Identities, Stories of Peoplehood, and his book, Civic Ideals, Conflicting Visions of Citizenship in U.S. History, was a finalist for the Pulitzer Prize in History. He also co-authored Still a House Divided, Race and Politics in Obama's America, and The Unsteady March, The Rise and Decline of Racial Equality in America. I should also say Rogers is my brother-in-law, and I'm so grateful for him being willing to come and talk with us tonight. Our other panelists tonight are Heaster Wheeler. Heaster is the Assistant Secretary of State from Michigan, the former Assistant CEO of Wayne County, the former Director for the Detroit chapter of the NAACP, and a former firefighter for the city of Detroit. Heaster, we're so honored to have you speak with us tonight. Jay Kaplan is the staff attorney for the ACLU of Michigan's LGBT project. Many of us know Jay's important work over many years, including challenging Michigan's constitutional amendment prohibiting same-sex marriage, and recently advocating for a transgender high school student being able to run for prom court. Jay, thank you so much for being with us here tonight. Lastly, Debbie Dingell is Michigan's 12th District Congresswoman in the U.S. House of Representatives. She's the former chair of Wayne State University Board of Governors and former president of the General Motors Foundation. Unfortunately, because the infrastructure bill is being debated and possibly voted on tonight on the House, Debbie called to express her deep regrets that she's not going to be able to join us tonight. However, she sent Kelly Tabay, her deputy chief of staff, to speak briefly on her behalf. And Kelly, we're so grateful that you're also with us here tonight. So with that, Rogers, you're up.
Thank you so much, Joe. I'm going to share my screen now. I want to start by saying I'm thrilled to join these great panelists, Inclusive Justice, and all of you tuning in to discuss the fight for full equality under the law, focused on the 14th Amendment. On reflection, I modified the initial title of my presentation slightly. That's because while it's true that the 14th Amendment is crucial to many struggles for full equality in America, and that it has needed defense in the past and the present against efforts to gut it, it's also true that the 14th Amendment has some limitations. So Americans need to extend it as well as defend it. Let me start my story of the 14th Amendment more than a decade before its ratification with the notorious Dred Scott decision of 1857. There, Chief Justice Roger Taney held for a divided Supreme Court that first, the Constitution protected property rights in enslaved persons, and second, that no person of African descent could be a citizen of the United States. According to the Constitution, Taney ruled Black persons had no rights which the white man was bound to respect. One striking feature of the decision was that Taney did not have to make these claims to decide the case. It was brought to the federal courts on the basis of what is known as diversity of citizenship jurisdiction, meaning cases that are disputes between citizens of different states. Dred Scott claimed to be a citizen of Missouri who was wrongly being treated as enslaved by John Sanford, a citizen of New York. So federal courts had diversity of citizenship jurisdiction, it appeared. The Missouri Supreme Court had recently ruled, however, that Dred Scott was not a citizen of Missouri. By its laws, he was enslaved. Like most constitutional conservatives, Taney generally deferred to states' rights and the judgments of state courts. So he could have just said, Missouri says Dred Scott is not a citizen of that state, and so he cannot get into federal court under diversity of citizenship jurisdiction. Case dismissed. Taney said a lot more, however, because he had bigger fish to fry. Through his two main holdings, Taney wanted to establish a pro-slavery, white supremacist interpretation of the Constitution as a matter of undisputed federal law. He failed. Instead, the decision spurred more intense disputes that contributed to the Civil War. Figures like Frederick Douglass and Abraham Lincoln denounced the decision as hostile to the spirit of the Declaration of Independence and its goal of securing basic rights for all, which they thought should guide constitutional interpretation. The Civil War increasingly became a struggle for that goal. As he died to make men holy, let us die to make men free. But even as the war was finally being won, it was clear that to repudiate the Dred Scott reading of the Constitution definitively as a matter of law, it was best to amend the Constitution itself. The first attempt to do so was not the 14th Amendment, but the 13th. It's much shorter than the 14th. Its first section overturns Taney's first main holding in Dred Scott. Rather than slavery being constitutionally protected, the 13th emphatically says that neither slavery nor involuntary servitude shall exist within the United States, except as punishment for a crime. That qualifier was put in so that the amendment could not be interpreted as banning all punishment, though that proved a destructive loophole that racist whites would later exploit. The framers of the 13th Amendment weren't too worried about that, though, because they controlled Congress, and the 13th included an unprecedented second section. Congress shall have power to enforce this article by appropriate legislation. No previous amendment had given Congress this kind of enforcement power, though it became customary to do so after the 13th. Section 2 of the 13th Amendment shifted governing power from the states to the national government, specifically the Congress, because after all, the states were the ones that had legislated slavery and gone into rebellion. And it was the national government that had restored the Union and begun to end slavery. National action has often proven necessary to secure basic rights ever since. Leading supporters of the 13th Amendment, like the Pennsylvanian radical Thaddeus Stevens, who was actually more fearsome looking than Tommy Lee Jones, believed that Section 2 of the amendment gave Congress broad powers to pass sweeping civil rights laws, to legislate against every form of discrimination and injustice that Congress saw as connected to slavery, as a badge or incident of slavery. After the ratification of the 13th Amendment in 1865, Congress went on to pass the 1866 Civil Rights Act, declaring African Americans to be citizens and seeking to protect their civil rights, particularly their economic rights and their rights in the civil and criminal justice systems, against Southern white efforts to reinstate forced labor and white supremacy. Many conservatives like President Andrew Johnson and even moderate whites protested, however, that the 1866 law went beyond the rather vaguely stated enforcement powers in the 13th Amendment, which they wanted to interpret as being aimed only at chattel slavery, not other forms of racial discrimination. So Congress went on to adopt the much more extensive and complicated 14th Amendment. The 14th Amendment contains 5 sections, and I'll say something about them all. But Section 1 is what most lawyers think of when they think of the 14th. Section 1 contains 4 main clauses, 2 having to do with rights of citizenship, 2 having to do with rights of persons, not just citizens. The 2 clauses on the rights of persons have been the most frequent basis of litigation in the entire Constitution since their enactment. But the first clause is what is known as the Citizenship Clause. The 13th Amendment directly overturned the first holding in Dred Scott that slavery was constitutionally protected. The 14th Amendment Citizenship Clause overturns the second holding in Dred Scott that no person of African descent could be a citizen of the United States. The clause is the closest thing that the Constitution has to a definition of citizenship. And it says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All persons. That emphatically includes all persons of African descent. So now Dred Scott is history. But there is a qualifying phrase in the 14th Amendment Citizenship Clause. It applies to all persons born or naturalized in the United States and subject to the jurisdiction thereof. Just what this means and who it leaves out has been a subject of dispute. Everyone agrees that it was meant to exclude children of foreign ambassadors or children born to an occupying foreign army because those children are seen as born subject to the jurisdiction of their home countries. The main goal of the clause, however, was to exclude children born into the native tribes who were subject to the jurisdiction of the tribal governments and who many of the framers of the 14th did not want to be citizens. Their language wasn't well chosen, however, because most of them saw the tribes as, quote, domestic dependent nations that were ultimately subject to the jurisdiction of the US government. And in fact, 3 years later, a Congress that included many of the same men who adopted the 14th Amendment would end making treaties with the tribes and begin legislating over them directly, which is pretty clearly subjecting them to US jurisdiction. Even so, in 1884, in Elk versus Wilkins, the Supreme Court ruled that persons born into tribes were still not US citizens under the 14th Amendment because they were not born under the full or sole jurisdiction of the United States. Then in 1901, in Downs versus Bidwell, the court ruled similarly concerning persons born into unincorporated territories, territories not placed on the path to statehood, notably territories like Puerto Rico and the Philippines acquired in the Spanish-American War. These territory-born persons were also not born sufficiently under the jurisdiction of the US to be 14th Amendment citizens, according to the court. Those rulings still stand, though Congress has since made all members of the indigenous tribes and most persons born in the territories into citizens via legislation, not via the 14th Amendment. Since legislation can change more easily, the subject to the jurisdiction phrase is one of the limitations of the 14th Amendment I mentioned. Today, some born into America's territories are suing to be recognized as 14th Amendment citizens. But as recently as last month, the federal courts continue to say no. The second clause of Section 1 of the 14th Amendment, known as the Privileges and Immunities Clause, also concerns citizenship, and many expected it to be the most important clause in the amendment. It says that no state shall abridge the privileges and immunities of citizens of the United States, as states where Southern whites regained control were doing to Black citizens. But in fact, this clause has proven to be the least important and least litigated one in the amendment, because the Supreme Court interpreted it very narrowly in a major 1873 decision known as the slaughterhouse cases. There, a 5-4 majority of the court said the Constitution recognizes two sorts of citizenship: state citizenship and U.S. citizenship. The 14th Amendment, the majority rule, protects only the privileges and immunities that uniquely belong to U.S. citizenship, like the protection of the U.S. government when citizens are overseas. But most rights, the court held, are privileges and immunities of state citizenship. And that meant the states could continue to regulate them in any reasonable way. There are huge problems with the court's reasoning, but this decision has never been overturned. And as a result, the Privileges and Immunities Clause has played only a tiny role in our political and constitutional development. Why did the court read that clause so narrowly? No one knows for sure, but the court consisted then mostly of moderate Republicans. And in 1873, moderate Republicans were worried that their party had been losing seats in Congress to Democrats in recent elections, in large part because many whites throughout the country saw the GOP as trying too hard to champion African-American rights. Many whites were tired of that. Now, the slaughterhouse decision did not directly involve Black Americans. It was brought by white litigants, butchers in New Orleans. And so, intentionally or not, it provided the court with a way of limiting national powers to protect the rights of Black U.S. citizens without appearing to rule against them. That long proved catastrophic. Next come the two great Section 1 clauses on the rights of persons, the ones that have been the gushing fire hoses of constitutional litigation ever since, the Due Process and Equal Protection Clauses. Courts have long interpreted the Due Process Clause to protect persons against arbitrary, unreasonable infringements of their life, liberty, or property by the states. A similar clause in the Fifth Amendment protects persons against infringements by the national government. The Equal Protection Clause was, in contrast, something new. It required all states to protect all persons equally. That has never meant that state laws must treat people identically. Every law actually divides people into at least two categories, those who follow it and those who don't, and it treats those categories differently. But the Equal Protection Clause means that when the states treat people differently, there must be a good reason for doing so. The courts have at various times weakened and strengthened the legal safeguards provided by the Due Process and Equal Protection Clauses, and I'll say more on that later. For now, please note that these clauses say that no state shall deny persons due process or equal protection of the laws. Unlike the 13th Amendment, which bans involuntary servitude imposed by anyone, a state government or a private corporation or a church or an individual, the 14th Amendment only regulates what is called state action, that is, governmental actions. It does not apply to private groups or individuals. That, too, is an important, much disputed limitation built into the 14th Amendment. Now, let's at last leave the momentous Section 1 of the 14th Amendment and go through the less known other four sections. The first is Section 2, which has never been enforced, so we don't hear a lot about it. But it's significant for a couple of reasons. First, it allows the national government to reduce the representation in Congress of states who are denying the vote to their citizens, something that may prove relevant in our own time. But note the second thing. Section 2 reduces representation only if states are denying the vote to their male citizens. And it's also okay to exclude, quote, Indians not taxed. This was the first time the restriction male was placed in the Constitution, and feminists in the day bitterly opposed it because it effectively legitimated denying the vote to women, even as it also denied the vote to Native American men living in tribes. These were indications that the 14th Amendment framers saw the citizens provided for in Section 1 as fundamentally white men and now Black men, 21 or older, but not anyone else. Those limitations are part of why the 14th Amendment has often needed to be not just defended, but extended. Then comes sections 3 and 4, also little enforced historically. But section 3 again may have contemporary significance as it bans from federal offices those who have engaged in insurrection against the United States, as arguably some folks did on January 6th. Section 4 indicates that the US government will not pay the debts of the Confederate States, nor will it compensate former slaveholders for loss of their enslaved persons. That was a price federal officials, including Lincoln, had been willing to pay at the start of the Civil War, but decidedly not at its end. Things had changed. And then comes the last section, section 5. It's like section 2 of the 13th Amendment. It gives Congress new powers to enforce the amendment by appropriate legislation. Soon after the adoption of the 14th Amendment, some federal judges interpreted section 5 to mean that if a state failed to provide all persons with equal protection, if it protected some but not others against abuse, discrimination, and violence by private groups and individuals, then that state inaction could justify Congress stepping in and legislating to give persons equal protection. On this interpretation, section 5 gave Congress lots of power to protect the privileges and immunities of citizens and the due process and equal protection rights of all persons. But in the huge cascade of 14th Amendment litigation that began in the 1870s and that has continued to rise almost unabated to the present day, many of the greatest promises of the 14th Amendment to provide and protect the rights of citizens and persons went unfulfilled for long, long stretches of time, and important ones remain unfulfilled. I've already noted how the Supreme Court almost immediately enfeebled the Privileges and Immunities Clause in 1873, and how it went on to deny that citizenship by birth extended under the 14th Amendment to tribes members and to those born in the so-called unincorporated territories acquired in the Spanish-American War and thereafter. However, the story is in fact even worse. In Bradwell, Illinois, and Minor versus Happersett in the 1870s, the Supreme Court confirmed in the spirit of Section 2 of the 14th Amendment that even though women were both persons and US citizens, states could deny them economic and political rights, the right to practice law, the right to vote. Under the reasoning of the slaughterhouse cases, those were more rights of state citizenship, still subject to state regulation. In the civil rights cases of 1883, the court said that Congress could not ban racial discrimination in places of public accommodation, like inns, restaurants, theaters, trolley cars, and trains. Those were private businesses, so their actions were not state actions that Congress could reach. It was up to the states to regulate them. But even if the states failed to do so, even if states did not ban racial discrimination in such places, the court now held that Congress could not treat this state inaction as a kind of action that justified national legislation. And finally, in Plessy versus Ferguson, 1896, the court added that even if there was state action in the form of state laws requiring railroads to place white and black passengers in separate racially segregated cars, those state actions did not violate equal protection, so long as the segregated cars were at least roughly separate but equal. With that decision, many states and towns in the South, but also in parts of the Midwest and lower Northeast, began adopting many sorts of Jim Crow segregation laws, as well as measures that denied the vote and jury service to Black Americans and to Latinos and Asians in the West, and often to poor white Americans. On that last point, I should also note that in these decades, in the late 19th and early 20th century, when the Supreme Court was denying much protection for people of color and women under the 14th Amendment, it was using the amendment to uphold the economic privileges and immunities of employers, businesses, and corporations. In the massively influential case of Lochner versus New York, for example, the court used the Due Process Clause of the 14th Amendment to overturn a unanimously passed New York state law that tried to set maximum hours for bakery employees in order to curb worker exploitation. Those decisions turned the amendment into a shield to protect economic inequalities rather than a source of economic equal protection. Fortunately, these grim developments are not the whole story. Starting in the early 20th century, accelerating after World War II, and continuing well into the 21st century, legal advocacy groups, social movements, and yes, even some politicians have often reinvigorated the 14th Amendment to promote especially the due process and equal protection rights of persons. Beginning with Moore v. Dempsey in 1923 and accelerating through the 1960s with famous cases like Miranda versus Arizona, the Supreme Court ruled that the 14th Amendment's due process clause imposes a whole range of higher standards on state criminal justice systems. The court has done so as part of extending most of the Bill of Rights, including all the great rights of the First Amendment, against the states. Beginning with Shelley versus Kramer in 1948, the court has also held that the 14th Amendment's Equal Protection Clause prevents courts from enforcing racially discriminatory contracts. Of course, in Brown versus Board of Education in 1954, the court decided that racial segregation in public schools, and soon after all other public facilities, was not consistent with the Equal Protection Clause after all. Then, in Griswold versus Connecticut, 1965, the court found a fundamental right of privacy in the Constitution. Though for many years, the justices didn't agree on just where in the Constitution that right is located, the court has come over time to link it most closely to the liberties protected by the 14th Amendment's Due Process Clause, as well as the Fifth Amendment's Due Process Clause. In 1973, in Frontiero versus Richardson, the court began ratcheting up the protection the Equal Protection Clause gives to women as well. And many, many more examples could be added if we had all night. Beginning with the 1964 Civil Rights Act, moreover, Congress also began to cite its 14th Amendment Section 5 powers as one authority for federal civil rights laws. Though, because of that state action limit in the 14th Amendment, it has rested civil rights protection most frequently on its powers to regulate commerce. And most strikingly in recent years, the court has, in various decisions, relied on both the Equal Protection Clause and the privacy and liberty protections it finds in the Due Process Clause to hold that states cannot ban same-sex intimacy, the ruling in Lawrence v. Texas, and that states must recognize same-sex marriages, the ruling in Obergefell versus Hodges. I'm afraid there's a mistake with my PowerPoint, so I can't show you the remainder of my slides, but there's just a couple more. I want to note that both Lawrence v. Texas and Obergefell versus Hodges had opinions authored by a Reagan appointee, Justice Anthony Kennedy, and just last year in Bostek versus Clayton County, the court, in an opinion written by Trump appointee Justice Neil Gorsuch, also decided that the 1964 Civil Rights Act's protections against sex discrimination extend to protection against discrimination on the basis of one's preferred sexuality. These recent decisions, which once seemed unimaginable, came about because litigants persuaded state and federal courts to stop asking the question of whether Americans have traditionally valued heterosexual intimacy in marriage. Instead, they began focusing on a different question. What is the harm of same-sex intimacy and same-sex marriage? What reason do governments have to restrict these pursuits of happiness? Under the Constitution and the 14th Amendment in particular, with its goals of equal protection and basic liberties for all, this was the right question to ask. And the courts soon found that there is absolutely no evidence of harm, just offense to some people's religious and moral beliefs from these practices. But since the Constitution forbids the establishment of religion and guarantees equal protection to all beliefs, the courts had to conclude that there wasn't any valid reason to restrict people's liberties in these ways. Nonetheless, from the standpoint of full equality, all is not rosy. In cases like San Antonio School District versus Rodriguez, which involved unequal school financing, the court has long steadfastly denied that laws that impact people differently because of differences in wealth, or laws that involve an explicit wealth classification like a pricing or taxing system, violate the 14th Amendment's Equal Protection Clause. With very few exceptions, the court treats economic inequalities as inevitable products of the American way of life. And though the dominant interpretations of the 14th Amendment now provide more extensive protections of many kinds to more diverse people, still many of the original limitations remain, if often in diminished forms. The 14th Amendment still provides less protection to LGBTQ plus persons, disabled persons, women, tribal and territorial inhabitants than many would like to see. Congress has often been a better route than the courts to get more effective weapons in the fight for full equality, but state action limits on its 14th Amendment enforcement powers persist, and state failures to protect people are still not deemed state actions that Congress can correct. The privileges and immunities of U.S. citizenship are also still read narrowly in ways that limit both congressional and judicial powers to protect those rights, most often political rights, that are unique to citizens. There is then still much to be done in the fight for equality in America. And many of the most important fights cannot be won just by appealing in legal briefs to the text of the 14th Amendment. Much must be done in Congress and state legislatures and city councils and in the great array of other public and private agencies and organizations that shape our shared lives if we are to achieve equality for all. In so doing, however, we can always appeal to a central dimension of the 14th Amendment I've only touched on lightly tonight, the spirit of the 14th Amendment. That spirit was shaped by a Republican Party that was very different from the GOP today, a Republican Party that counted Thaddeus Stevens, Frederick Douglass, and Abraham Lincoln among its leaders. Those Republicans saw it as the mission of the 14th Amendment and all of the Constitution to carry forward the great project of the Declaration of Independence. That project was and is to create forms of government and forms of economic and social life that provide real opportunities to enjoy securely the fundamental rights of life, liberty, and the pursuit of happiness. Those opportunities must ultimately come to be shared, as Lincoln put it, by all people of all colors, everywhere. Until those basic rights and opportunities are securely possessed by all, the American Declaration of Independence project must be considered unfinished, and the fight for full equality must continue. I hope that this need for continued struggles and the story of the 14th Amendment's ups and downs and strengths and limitations that I've told tonight, I hope these don't sound discouraging. I think that, in fact, we can and should see it as not just our civic duty, but as a great privilege of our citizenship and our humanity, that we can join in that fight, defending and extending the 14th Amendment's promise of equality as much and as far as we can. Thanks, and I look forward to our discussion.
Thank you, Rogers. So, Rogers, just grateful for that talk. That was a lot. Whew. Coming at us, but such important history. And such important history for us to reflect on at this critical juncture in our nation's history. So very grateful for you for laying out these challenges. Interested in your thoughts and our other speakers' thoughts on this struggle ahead in terms of the challenges you've posed to us. So I would like to invite, on behalf of Representative Dingle, Kelly, would you like to start off tonight saying a few words?
Sure. Thank you, Pastor Summers. Appreciate it. And good evening, everyone. And thank you, Rogers, for that very insightful program. I'm Kelly Tebay. I'm Congresswoman Dingell's Deputy Chief of Staff and District Director. Congresswoman Dingell regrets that she couldn't join us tonight for this important discussion given votes on the House floor, as Pastor Summers mentioned. The topic of equal rights and the struggles to achieve them are extremely important to Congresswoman Dingell. It's a huge reason why she fights so hard for the people of Michigan's 12th District. Our country is in this pivotal moment to ensure everyone is protected from racial injustices and discrimination based on gender or sexual orientation. Earlier this year, Rep. Dingle cast her vote in support of the Equality Act, which passed the House. As an original co-sponsor of the legislation, Rep. Dingle celebrated the historic expansion of anti-discrimination protections for LGBTQI Americans with regard to employment, education, access to credit, jury service, federal funding, housing, and public accommodations. No one should have to face discrimination for who they are. The Equality Act is just one step in the right direction, but we need to ensure that everyone, regardless of race, capabilities, sexual orientation, income, or zip code, have critical human rights protections under the law. That's why this conversation and defending the 14th Amendment is so important. We're not going to get to the point of full inclusivity and protections for all without ongoing discussions like these with so many advocates. On behalf of Congresswoman Dingle and our team, we are incredibly grateful for your leadership on human rights, and we are committed to working with you all in this fight for full equality under the law. Thank you so much for having me.
Kelly, thank you. Let's have a hand for Kelly, and please express our thanks to Representative Dingle for the important work she's doing.
I will. Thank you so much.
Tonight. And I forgot to say, let's also have a big hand for Rogers. Rogers, thank you, thank you. I'm sorry, our attendees, we can't see you on the screen, but thank you all. Heaster, would you like to go next?
Reverend Summers, thank you very much. First of all, let me also say a very, very special thank you to Kelly Tebay. Please give Debbie Dingell, Congresswoman Debbie Dingell, my very, very special regards. And it is always a pleasure to see you. Keep doing what you do. You guys make a lot of good things happen for a lot of people. So I am deeply appreciative. Professor Roger Smith, if I could not be me, I think I would like to be you. You are such a brilliant political scientist. I think your presentation this evening was nothing short of excellence. I am a student of history. I love politics, and equally, I love politicians. I love people who offer themselves up to service, but I'm especially appreciative of people who do the research and develop that unique ability to make it plain. You just articulated a reality that many of us live. And you have just helped us to understand why I thought your presentation was just exceptional. And I hope that's a part of a roadshow. You need to be all across this country and all around this world with those set of facts. It is especially significant. I've often thought about the Dred Scott decision in particular, that Black people have no rights that white people are bound to respect. Doesn't that sting? Doesn't that sting? And I've lived that reality. I often tell the story of my parents, both from Mississippi. We were born and raised in Detroit. I'm one of 10 children. And when we were young, we would have to split up to determine which 4 or 5 of us could travel back and forth to Mississippi. We only had one car. And so 4 or 5 of us in the back, mom and dad in the front seat. This was the big experience of our childhood. My parents, my dad was very, very deliberate with how he chose to travel. He would normally like to leave in the middle of the night so he could cover a lot of ground before daybreak. And he always wanted to arrive in Mississippi before dinner. But he also wanted to avoid unnecessary interactions with police. Interestingly, most families don't even have to think about it. Most American families don't have to think like that. My mom would cut a bunch of apple slices. She would bake a cake and fry chicken, and she put it in a shoebox that she kept under the front seat. And I did not know until I was much older that public accommodations were not a real experience for them. And the ability to stop and use the restroom, the ability to stop at a diner to pick up a burger or a milkshake, they did not know that experience as real. So that's why we had fried chicken, pound cake, and sliced apples up under the seat. That was my reality. That was the reality that I was born into. So you just captured it like the expert that you are. So I think in my next life, Professor Rogers Smith, I might consider doing something professorial because I just think you guys are brilliant. So the fight for full equality under the law, isn't this something, put this thing in, I want to add another layer of historical perspective as it relates to African Americans. Think about this. Think about what was happening in America, 1619 to 1865. What was going on in America? Slavery. America's original sin, abject brutality, man's worst example of inhumanity to other human beings. From 1865 to 1965, roughly, what else was going on? Segregation, Jim Crow. It was legal. It was legal to treat people as second-class citizens after treating them as something lower than animals. And then think about this, how current this reality is. It's only been since roughly 1965 through today, 2021, some 56 years or so that we've had something else. And what is that something else? We've only had some 56 years of something else. So my parents were born in a different reality. I too was born prior, I know I don't look like it, but I was born prior to 1965. So I know a little bit about that, but it has been, and you think about the history of the civil rights movement, really starting in the 20s and 30s with sit-ins and various forms of protest and demonstrations. And we didn't get to the crescendo until, as you discussed, it was Rosa Parks and Emmett Till. Because of Jim Crow laws, it was commonplace to kill a Black man for looking at a white woman. That was Emmett Till's crime. And Rosa Parks, she challenged the public accommodations law, the same thing you described with Plessy versus Ferguson in 1896. Most people don't know what most people don't know. A part of the reason we're having a debate about this thing called critical race theory, that ain't no foreign concept. Guess what critical race theory is? It's American history. It is very simply American history. It ain't nothing far-fetched. It's just the truth about American history. But you look at the lynchings and the church bombings and the police brutality, that has been the African-American reality even since Emmett Till and Rosa Parks and the Civil Rights Act of 1964 and the Civil Rights and the Voting Rights Act of 1965 and the Fair Housing Act of 1968. So while we have made some significant progress, I agree with you, Professor Smith, we have much work to do. And we all have to be driven by our humanity. I'm not radically surprised because that things are where they are and that Mr. Trump, for example, had so much success. We looked at the voting records. 57% of Michigan voters voted for Mr. Trump. Do you guys know that? 57% of white Michigan voters. 57% of white Michigan voters went with Mr. Trump. That means this state is radically divided. 87% of African Americans voted for Mr. Biden and Ms. Harris. I mean, we are still radically divided. And then if you look at the legacy and the history and the impacts of public policy racism, Professor Smith and Kelly, you guys have already articulated quite a few ongoing challenges, the reasons why we have to deepen our commitment to fight. And let me give you a solution right up front. If you don't hear anything else I say, I have a lot of friends who say, I'm not a racist. And let me be clear, it is not enough to say you're not a racist. In my opinion, you have to commit to anti-racism. You do not have to wait for a Heaster Wheeler to speak up when you know something is wrong. You do not have to sit by idly and wait. Well, what does the black guy say? What are the black people saying? You know right from wrong. Most of you came out of the same value system that I came out of. So let me highlight a few things about Michigan elections and help you to crystallize as to why we are in the fight we are in. First of all, the November election was the safest, it was the most secure, it was the most accurate election in our history. Even in the midst of a global pandemic, record-breaking voter turnout, and that is a sign of voter confidence. So most of what you hear is a big lie. It is a solution in search of a problem. In spite of the coronavirus pandemic, the Black Lives Matter protests, people went to the polls in record numbers. And across the nation, Black voters had a tremendous impact on the outcome of this election. I don't know if we talk about it at the level we really should, but folk on the other extreme of the political spectrum, they know that. Despite the many attempts to suppress the voters, our duty is to protect the vote of all Americans by countering misinformation, prosecuting those who intentionally perpetuate fraudulent information, and exposing the lies. That's what Jocelyn Benson, our Secretary of State, and Heaster Wheeler, and many of us have been doing since long before election day. So we must be resolved in our duty to advance the vote and protect democracy. So thank you for inviting me to this important process. Let me share with you a few more statistics. 5.5 million Michigan voters participated in November. And guess what? 3.3 million voted via the absentee process. Michigan delivered new voting rights, no excuse absentee voting, same-day voter registration. It mattered, particularly in this COVID-19 environment. We literally flipped the scripts. Traditionally, about 1 out of 3 voters participate through the absentee process. This time, it was nearly 2 out of 3. People took advantage of Michigan's new voting rights. And guess what? 30,000 people registered and voted on election day for the first time in Michigan history. That's thanks to all of you for helping to deliver on Michigan's new voting rights. It mattered. It made a difference. Those Black Lives Matter protests, they made a difference, whether you acknowledge it or not. There were protests in all 50 states and 60 plus countries across this world. All of that protest turned into power at the voting booth. And the other side took note. One thing that is indisputable about this election is that in Michigan and across the nation, Black voters had a tremendous impact on the outcome. Nationwide, Black voters make up some 12, 13% of the electorate and representing some 30 million people. Guess what? Did you know that nearly 1/3 of all registered Blacks live in 9 battleground states? Did you know that? 1 out of 3. And guess where those battleground states are? Places like Georgia, 22%, North Carolina, 22%, Florida, 14%, Michigan, 14%, Ohio, 12%, Pennsylvania, 10%. And we saw the impact of Black vote as cities with large Black populations began reporting their counts, effectively deciding the election. You guys remember where you were on election night? When they went to North Carolina, they had to wait for Greensboro to come in. When they went to Pennsylvania, they had to wait for Philadelphia and Pittsburgh. When they went to Georgia, they had to wait for Atlanta to come in. When they went to Wisconsin, they had to wait for Milwaukee to come in. Those were major urban center, population center, communities of color, Black folk in particular. And guess what happened here in Michigan? The results of the election were not decided until Detroit came in. Detroit delivered 250,000 votes. Anybody remember the margin of victory here in Michigan? 154,000. 250,000 votes came out of Detroit alone. The rest of the state was fairly equally divided. So I am saying to you that this is a difficult time, but I believe in the greatness of humanity. I believe that there are way more good people than there are bad people. You've heard this rhetorical statement many times. I believe the things that connect us are greater than the things that divide us. I think that the solutions to the challenges we live today are squarely on the hearts of everybody on this call and people within the sound of our voice. African Americans are not going to solve the race issue in America. And if you don't see racism as an impediment to our progress, then you're probably not awoke. But what I would suggest, look at the public policy racism, and I'll wrap up with this, but auto insurance. We had a law in Michigan for a bunch of years called driver responsibility fees. You could be a drunk driver living in the suburbs and pay less than a perfect driver living in Detroit. And if you could not afford auto insurance for nearly 20 years, you were penalized and your licenses were revoked. You know what your life could look like if you don't have a driver's license, especially in a place like Detroit. You've got to get places. We've got a transportation system here, but it won't take you anywhere. It definitely does not take you to the suburbs and the exurbs and those communities where jobs and manufacturing activity takes place. Today, there are more than 58,000 Detroiters who used to have a driver's license that still don't have one. So since Jocelyn Benson and I have been on board, we've been trying to remedy that particular issue. But many of the challenges include things like failure to appear, or maybe there's some outstanding fine. Why should a person lose a driver's license because they don't pay child support? Tell me the connection between child support and traffic safety or driving privileges. Tell me the relationship. I too think if you have children, you should own the responsibility associated with that. But how did that become connected to driver's license other than public policy racism, public policy disparity, predatory lending and housing discrimination? I think you all know the reality. African Americans were built for the past several decades. So home ownership is probably one of the most significant cornerstones to wealth building. And the wealth in the African American community was stripped through predatory lending practices. Educational inequality, I don't think we have enough time tonight to talk about that particular issue, because I think you all know the reality. 30 years or so ago, we started talking about how bad Detroit schools were. Legislators went to work, they destroyed, disrupted the Detroit public schools, and 30 years later, we've yet to recover. There used to be 175,000 students in the Detroit public school system. Today, there are barely 50,000. And everybody else, they lied, they've changed their addresses, they're going to schools in the suburb. Those who can afford send their kids to private schools, and charter schools pick up the rest. And guess what? Charters are not necessarily the panacea. They have not performed any better than the traditional public school. Nowhere is there a record of that. And don't let me start talking about the disparities in the criminal justice system, from contact and conflict with police to prosecutorial priorities to sentencing disparities. We've got a ton of work to do if the 14th Amendment, if the fight for full equality under the law is ever going to be real. And this is not us versus them. Let me tell you why. Recently, we had some challenges in the Asian community. That's not just an Asian fight. That's all of our fight. But one of the reasons I highlight that, because it's current and it's relevant, we have to build friendships. We have to build relationships before we need them. I'll stop there. Thank you guys so very much. Happy to be here.
Esther, thank you so much. Jay, welcome.
Thank you so much, Joe. Man, I am just so inspired by both our speakers. Hester, what you had to say, and Rogers for your presentation. I also wish I had you in law school as professor. You explained the 14th Amendment so well. And I think, also the use of the 14th Amendment, one of the biggest threats to civil rights right now are these attempts through voter suppression bills that we're seeing in state legislatures, including the state of Michigan. Hester, I think these legislatures have taken note in terms of the power of the African-American vote and the influencing of elections, and they're coming up with legislation that would make it more difficult for communities of color to be able to access the polls. And I think the other thing that's somewhat new and even more dangerous is this idea that giving the state the power to refuse to certify the election results if they choose, or if they believe that there's been some irregularities in terms of the vote, giving credence to the big lie. And this idea that if you don't like the election results, that you, by virtue of being an elected official, you can cancel out that is so antithetical to our democracy. And it's something we all need to be concerned about because we see the passage in these key states that were integral to the Biden victory in 2020. I wanted to talk about the 14th Amendment and how it has been so important in terms of the movement for LGBTQ rights in this country. In terms of as far as civil rights go, when we look in terms of court victories, the history for the LGBT rights is relatively short. We're talking about a 35-year history, at least through the United States Supreme Court. And I'm struck by the first, seminal case involving was the case of Bowers versus Hardwick, which was a challenge to Georgia that had a sodomy law that criminalized same-sex sodomy between two consenting adults. And the challenge was brought before the United States Supreme Court. And the court majority, the way they viewed this was, is there a fundamental right to engage in homosexual sodomy? That's the way that they, chose to look at this. And they decided against the LGBT community, that these kinds of laws were constitutional. And in essence, what they did was they defined LGBT people solely in terms of presumed sexual behavior. So in other words, if I'm gay, I'm going to be presumed to be engaging in illegal same-sex sodomy, and therefore there is justification for discrimination against LGBT people. So this was a very disappointing result, and I think kind of what Roger's presentation shows you is how many times our court does not lead on civil rights, how many times they disappoint, and how many times we have to look to other branches of government to do the right thing. The next case did involve equal protection. And that was a challenge. It was the case of Romer versus Evans. It was a challenge to a Colorado law that voters approved that would prohibit state and local governments from passing civil rights legislation that protected gay and lesbian people. And it was challenged on equal protection grounds. And even though the United States Supreme Court said that because sexual orientation was not in civil rights laws, and therefore it's not necessarily recognized as a protected class, even applying the lowest level of constitutional scrutiny, that of rational basis, the court said, when a law is motivated by animus to try to hurt a particular group of people because you don't like that group of people, that doesn't even satisfy rational basis. Some people saw this as kind of the rational basis test with a little bit of bite, a little bit something more. But nevertheless, for the first time, the LGBT community had a tool that they could use to challenge anti-LGBT related legislation that was frequently introduced in state legislatures and in local communities. And so that was a significant step forward. Then we saw the reversal of Bowers versus Hardwick in 2003 in the case of Lawrence versus Texas that Rogers was talking about, where the court decided to look at the due process clause, the privacy interest, and the way they viewed this in terms this was Texas's law that criminalized same-sex sodomy. And so they viewed this in terms of privacy, the privacy of two consenting adults in their own home to engage in certain sexual behavior. And they found that laws that criminalized same-sex sodomy were unconstitutional, or even laws that criminalized sodomy between consenting adults were unconstitutional. And that was, once again, a huge step forward because no longer could people discriminating against LGBT people use this defense that, well, it was just my decision not to, for an employer, let's say, not to employ people who I can assume are engaging in criminal activity. And then, of course, the marriage equality cases. First, the Windsor versus United States, which was a challenge to Section 2 of the Defense of Marriage Act, which prohibited the federal government from recognizing legal marriages between same-sex couples. And then, of course, the Obergefell case, which said that marriage is a fundamental right, and to deny same-sex couples that fundamental right, as well as the benefits associated with a legal marriage, was unconstitutional. And that was decided on equal protection grounds, that the arguments that were made by the government to support denying same-sex couples the right to marry, the idea that we want to encourage procreation, and marriage is a vehicle for procreation. Well, the fact is that there are couples who get married who can't procreate or choose not to procreate. The argument that children do best when they're raised with parents of the opposite sex, that also was refuted by actual science and studies showing what children really need is a stable home with parents who parental roles who can provide that stability for them. And what we also saw in terms of those two cases were the first time that the Supreme Court we're looking at LGBT people as as people, the dignity afforded to same-sex relationships and their families, and the impact these discriminatory laws and policies have on their children. For the first time, the court really defining LGBT people in human terms. And then, of course, the Bostock case was not about equal protection, but it was looking and interpreting a federal civil rights law that prohibits sex discrimination and saying when you discriminate against LGBT people, you're doing it on the basis of sex. Based on either the sex that was assigned to them at birth, as to whom society believes they should be attracted to, romantically attracted to, or how they should identify in terms with their gender. So we've definitely come a long way. But of course, with any success you see in a civil rights movement, you also see a backlash. And what we've been seeing across the country just in the past year is this coordinated attack by a certain political party, I won't mention its name, but it's the Republican Party, in state legislatures to target transgender people for discriminatory treatment. Many of the opponents of LGBT rights realized that after they lost the marriage equality fight, they needed to find another target. And so they thought, what's part of the LGBT community that maybe society might not be as familiar with, that maybe somebody might not know someone who is transgender, and how can we use myths and mistruths about this population to be able to score some political points through our legislation. So what we've been seeing across the country in more than 24 legislatures, including in Michigan's legislature, are bills introduced that would prohibit transgender students from being able to play school sports in accordance with their gender identity. And the argument goes that somehow the presence of transgender students playing sports is taking away opportunities for cisgender girls to be able to play in sports. Once again, arguments that can be actually debunked by the actual facts and the actual studies. We're also seeing legislation that would prohibit providing affirming medical treatment for transgender youth. In Arkansas, a law was passed making it illegal for doctors to provide affirming treatment and also to refer a transgender youth to a medical provider who will provide that affirming treatment. And then in Tennessee, we saw a law passed that would require business owners and places of entertainment, if transgender people are using the restrooms in accordance with their gender identity, that they have to place a warning sign outside of these restrooms. These bills passed and signed into law, and in recent cases, these laws being enjoined, in other words, prevented from being enforced by federal courts, citing, in terms with the trans sports bill and in terms with the medical bill, citing the equal protection clause and finding under the level because of the Bostock decision, saying that this is sex discrimination, the constitutional scrutiny under the equal protection clause has been moved up from the most deferential to the government, the rational basis, to the heightened scrutiny. And the government has to show that this legislation advances an important governmental interest and that this particular legislation is substantially related to advancing that interest. And in these recent case decisions in Idaho and in West Virginia, where the sports bills were struck down, the court found that the government failed to meet that standard. And I wanted to quote from the West Virginian case, Judge Goodwin made a statement about some of this legislation, which I find so heartening, and it's so important to keep in mind, making it very clear, what's the impetus behind this sort of thing. And what he said was, a fear of the unknown and discomfort with the unfamiliar have motivated many of the most malignant harms committed by our country's governments on their own citizens. Out of fear of those less like them, the powerful have made laws that restricted who could attend what schools, who could work certain jobs, who could marry whom, and even how people can practice their religions. Recognizing that classifying human beings in ways that officially sanction harm is antithetical to democracy, the states ratified the 14th Amendment. It ensures that no state may deny to any person within its jurisdiction the equal protection of the laws. So I guess my point is the equal protection is such an important tool. It has certainly made a great advancement in terms of civil rights for the LGBTQ community, but it's also such an important tool that we can use to combat the discriminatory legislation that we're seeing right now. The Tennessee law that was enjoined, that was on different grounds. They were talking about that constituted compelled speech. Ordering business owners to have to engage in a message that might be antithetical to their actual principles about what they believe. We're also seeing equal protection being used for good things in the state of Michigan. And as Heaster has mentioned, elections do have consequences, and we've seen some significant gains in the state of Michigan because of the people that we elected. So we have a Secretary of State who changed the gender marker policy for driver's licenses and state IDs in November of 2019, no longer requiring transgender people to go through some arduous hurdles in order to get accurate state ID. Now they can do this through self-attestation. And just a month ago, our Attorney General, Dana Nessel, looked at Michigan's birth certificate statute that requires transgender people, in order to get an accurate birth certificate, they have to prove that they've undergone gender reassignment surgery. That requirement left out a significant portion of the transgender community, including trans youth, who either cannot get the surgery, do not want the surgery, couldn't afford the surgery. There might be medical consequences as a result of that surgery. Now, as a result of Attorney General Nessel finding that to be unconstitutional based on the due process clause, the right of privacy for people to make their own decisions concerning the medical procedures that they want to undergo. Now this means that many more transgender people in the state of Michigan are going to be able to obtain accurate birth certificates, which is so important for their ability to live their authentic lives and to not be outed as being transgender, because we know the degree of discrimination against them. So these are other examples of how equal protection can be used, even at the state level, to further LGBT civil rights. We still have a long way to go. As was mentioned, the Equality Act, which would include persons with disabilities, and it would cover public accommodations, would be the first comprehensive civil rights act that specifically and explicitly mentions sexual orientation and gender identity. And it's stuck because we have the filibuster rule in the Senate and 10 Republican senators unwilling to vote to move this bill forward. And it's not going to be able to go forward unless there's some kind of reform to the filibuster rule, or some magical way we're going to find 10 senators who are going to be on board with the bill. We have the same problem in the state of Michigan. We have civil rights legislation that would explicitly add sexual orientation and gender identity, but the Republican leadership refuses to allow those bills to move forward. And the only way they will do is unless there's a broad religious exemption, which includes non-religious activity when it comes to LGBT people, which effectively would gut the civil rights protections. So, in closing, I think the Equal Protection Clause is such an effective tool. We're going to need to use it, certainly with these voter suppression bills and bringing these challenges that clearly the intent behind these bills were to deprive communities of color the right or the access to vote, and certainly have a disproportionate impact on the ability of these communities to be able to participate in elections. Thank you.
Jay, thank you so much from all of us.
Hey, Reverend, can I just add, Jay talked about the gender identity addition to our driver's license. We were barely in Lansing 2 weeks and Jay was sitting in our office. He almost single-handedly made that happen. So job well done, Jay.
Thank you. You give me a lot more credit than I deserve, Heaster, but we say elections have consequences. The LGBT community gets emails and phone calls returned, their ability to have meetings and to discuss these issues. That wasn't true with previous administrations. You could send a letter, you make a phone call, and you wouldn't get any response. So it's so important that people have an understanding. It definitely matters.
It does matter. Yes, sir.
So while we're waiting, let me put a question before the panel. And it's one that came up in Jay's question. People argue that freedom of religion means that they should be able to discriminate against others on the basis of their faith. In the past, the courts ruled that religions couldn't justify racial discrimination in terms of public accommodations or services on the grounds of their religious beliefs. We're now seeing similar efforts to justify discrimination on the basis of sexual orientation or gender identity on the grounds of religious freedom. Do you have thoughts about how we can best achieve equality under the law while honoring the principle of religious freedom? And I realize this is just a tricky hot point, but it's right at the juncture of where the struggle is, as Jay said, in our state, with where our Civil Rights Act is literally being held up on the grounds of wanting to protect the right to discriminate.
I think it's so important to have this discussion. I think it's so easy to say the word religious freedom. You can put it on a bumper sticker and everybody thinks they know what that means, but it has to go much further. Our Constitution very strongly protects the freedom of religion. There's nothing that the government can do that can make somebody change a particular individualized religious belief that they have. And certainly the government is prohibited from intervening with the religious and ministerial activities of a religious institution and organizations. But our courts have never viewed this freedom of religion as a right to use a sword to harm other people. And what we are seeing is our attempts to try to broaden in terms of the so-called religious freedom principle as to be exempt from having to comply with certain kinds of laws. And I regret to say, I think there are certain members on the United States Supreme Court who are open to that argument at this point in time. We now are dealing with a 6-3 conservative majority. Recently, there was a case involving LGBT rights. It was the case of Fulton versus Philadelphia. And there was a lot of fear about what the court might say. The issue before the court was, does a faith-based organization that has a government contract to provide foster services, are they entitled to have that contract and also be exempt from civil rights policies that prohibit discrimination against LGBT people? Because this particular faith-based agency said they wouldn't work with same-sex couples. And the concern was that the court majority would come up with an opinion saying, yes, in terms of religious entities can be exempt from complying with civil rights laws and that they do have a right to a government contract. That's not what the court did. They decided on very, very narrow grounds. They looked at the particular situation with Philadelphia that, they had the civil rights policy, but they also allowed within the discretion of somebody with the Philadelphia government to grant exemptions. And because an exemption wasn't granted to this particular faith-based agency, they felt that it might have, that it constituted discrimination on the basis of religion. But I guess what I'm trying to say, we kind of, in essence, we kind of dodged a bullet for now. But there's going to be the continuous efforts, and certainly we saw in the past administration, the Trump administration, efforts through policy to allow LGBT people to be discriminated against in healthcare, in accessing in health insurance coverage, and in accessing homeless shelters in the name of religion. And we have to continue to have those discussions. When you have a discussion with people who consider themselves to be of faith, and you explain, in terms of religious activity, we have the separation of church and state, but we don't use this to harm other people in non-religious activity. Most people get it. Most people understand it. But we have to have many more conversations about this issue. I know that Reverend Rowland is doing a lot of work on this issue and community organizing and hosting forums to have an in-depth dialogue and discussion about this. And so people really have a clear understanding of what this really means. Because if we allow for this broad religious exemption, even for individuals, the ability to enforce laws and public policies, which our government believes are compelling interest, including eradicating discrimination, will be rendered meaningless.
Wonderful. I wanted to say, Joe, that there are a lot of great questions and many of them are already being answered. And so if you want to take a look at what the questions are, and our panelists have gone ahead and taken the liberty to respond to those questions, that is wonderful. However, if indeed you do have a question that you would like the panelists to respond on air, go ahead and put that into the Q&A and not the chat. Put any other comments that you want to make in the chat. But if you have a question that you want a verbal response to, or even a written response, put that into the Q&A. So that being said, there is one that has not been responded to, and it is from David, and he says, we talk about equality, yet in the system against the transgender community, the family dynamic is unsettling. Yes, he is no longer a dad, but what are their rights for the family? So Jay, that might go to.
Yeah, so I'm trying to make sure I understand. I'm assuming, David, you're talking about the idea in family court that there's a bias against transgender parents. And I think that's been true for many years, and a lack of understanding about what it means to be transgender. But I also, we have seen some progress made even in the state of Michigan. I have been involved in custody cases involving dispute over a parent who's transgender, and there have been courts that have been willing to be educated about this issue. What has to be the guiding star in terms of custody decisions concerning children and the rights of parents is that of what's in the best interest of children. And I think there's 12 different factors that have to be addressed. Certainly, we do see in courts the attempts by attorneys from the other side to try to demonize the transgender parent, to automatically assume that the fact that a parent is transgender is harmful to children. And what you need to do is you need to bring in people who have expertise on certainly related to trans issues, but on parenting issues, to be able to refute those kinds of arguments and not to accept those at face value. But certainly, a transgender parent, if there is a custody dispute, they're entitled to due process before the court. And the other thing I wanted to say is, obviously, the ACLU, we don't handle individual custody dispute cases, but we can make ourselves available to provide technical support or information or helpful resources to an attorney who is representing a trans parent.
Thank you. This is a question from Ian, and this is, I know, a question that many people have asked about the unequal power allocated to voters in smaller states relative to those in larger states. So by the constitutional allocation of 2 senators per state, doesn't that violate the 14th Amendment?
That's definitely Professor Roger Smith. How did we get to 2 senators per state regardless of population size?
Well, I'm afraid that the answer to that is, though it's disputed, is commonly recognized to be bound up with issues of race and slavery. The fundamental balance between the mode of representation in the House by population and the mode of representation in the Senate by states reflected the fact that the small states were concerned to make sure that they wouldn't be overwhelmed by the large states. But it's also true that the slave states recognized that the systems of representation in the House and the Senate needed, from their point of view, to be structured in ways that would protect their power in the federal government. And because at the time of the adoption of the Constitution, there had been a movement toward gradual ending of slavery in the North, but not in the South. The desire for every state to be equally represented was a protection for the Southern states, that they wouldn't be overwhelmed by free Northern states. And of course, the 3/5 clause contributed to that too. But I do want to note that the representation of states in the Senate can only be changed by the unanimous consent of all states, which means under the Constitution, which means it will never happen.
Never going to happen. That's
Small
right.
states will never give it up.
That's insightful. Yeah. And Reverend Roland Stringfellow, I'd like to respond to one of the questions I saw relevant to the future of America. What do we see? First of all, I would just like to say that I believe that there are way more good people than bad. I think bad people make the news a lot faster than good people, and bad news makes the news. But I think most folk want the exact same things. I think leaders, all leaders, not just political leaders, I mean community leaders and faith leaders and academic leaders, all have to be held to a standard that embraces fairness and equity and democracy. I don't think anybody should be given a pass. If you're a corporate leader, you cannot privately discriminate. If you're a faith leader, you cannot be narrow and benefit from any, particularly taxes. So I'm suggesting that we're closer. I believe we're closer to our future than we think. I know this is difficult, but I can tell you this. It's a lot easier for me to watch the news since January 20 than it was over the previous several years, just because there's a different tone, there's a different tenor, there's a different level of civility. And I don't believe most people want to live the kind of stress, even though Professor Smith, you highlighted an absolute reality that America was built on race and conflict. The American system that we know was built on race and conflict. And we have to be very deliberate to work through that kind of conflict. And there are so many brilliant people that teach classes on how to eliminate racism or how to embrace diversity and inclusion. And until it becomes a part of our education mainstream, we're having a very, very narrow argument about something called critical race theory, when that really, like I said earlier, is simply American history. We've got to be honest. And at some point, I remember Dr. King in one of his great speeches, he says, "No lie can live forever. The truth pressed against the earth shall rise again." And I think what you're seeing with this explosive energy around protests and demonstration, people know that there's too much propaganda. There are too many lies woven into the so-called American dream. And we've got to speak truth to power.
Let me read another question from someone we haven't heard from. This is Randy Block. I've heard that there is a group that is working to amend the Michigan Constitution to have a strict definition of the right to vote. Does anyone have any thoughts about the value and the possibility of changing the Michigan Constitution to better ensure voting rights?
Is that question from Randy Block? You say,
yes, it is.
Yeah, first of all, let me say special thank you to Randy Block for inviting me to participate. I am aware of a lot of fringe discussions. I am aware of a lot of proposals that are so narrow. I know that they will never see the light of day. I'm not aware of that particular proposal, but it sounds like something that deservedly is over in the margins, and hopefully that's where it stays. I'm not aware of that.
And it's interesting because in Michigan, we passed some voting reform legislation in 2018 that greatly increased participation. We got rid of gerrymandering.
Yes, sir.
Got increased hours and making it easier for people to register for vote. And I think that resulted in greater voter participation in our state in 2020. And legislation has been introduced that would roll back some of those protections and make it more difficult for Michigan voters to be able to participate. Fortunately, we haven't seen anything in terms of passed just yet, and it's highly unlikely that the governor would sign that into law. But there might be there has been talk, Randy, about a ballot initiative that would enable in the legislature to kind of bypass the governor.
And thank you for that, Jay. Let me just reemphasize a couple of things that you just articulated. In 2018, voters passed both Proposal 2 and Proposal 3 proposal 2 address, allows for redistricting, which is going on right now. It takes politicians out of the ability to draw the lines. We have a 13-member commission that was randomly selected and geographically selected to represent all of Michigan. But we talked about no excuse absentee voting, same-day voter registration. All of those laws contributed to the success we experienced in last year, 2020. And much of what you see is a reaction to that. 39 pieces of legislation have been introduced in Michigan that really takes Michigan, if any of those pieces of legislation were to prevail. But you're correct, the governor has already promised a veto on all of it. But if any of that were to prevail, this takes Michigan and right down to the bottom next to Mississippi. The reality is some of our mean-spirited legislators have introduced things that say in order to vote via the absentee process, you've got to make a copy of your driver's license and send that in with your application. We've asked for several pieces of legislation that have not seen the light of day. We've asked that the absentee ballot applications are mailed automatically. I think you remember last year we mailed 4.5 million absentee applications. Some of what you see is a backlash to the authority we use to just mail the applications unsolicited. We want that to become a law. We want to establish early in-person voting at all clerk's offices and satellite offices. We want that to become a part of the law. We want every ballot, if it's postmarked by election day, we want that ballot counted, even if it takes 2 days to get to that particular ballot. Those types of legislative recommendations that we've made have not seen the light of day. We want a couple real basic things. We don't want anybody to brandish a firearm at a polling place. We can't even get a committee hearing or a discussion about that. We want Election Day in Michigan to become a state holiday. We cannot get a hearing on things like that. Instead, some 40 plus states have introduced over 350 pieces of legislation that will take this country backwards. And the bad thing about it is over 20 states have already enacted at least one piece of legislation that heads in the right and in the wrong direction. Texas is the best example. You've got legislators who had to leave the state in order to shut that foolishness down. So we will be fighting, but the greatness of America, in my opinion, has been revealed in our right to protest for rights. So we might be fighting for a while, but I just encourage people, fight until we win.
I'd like to jump in here with a question for Rogers that's related to this struggle that, as you presented our law, I was hearing some kind of deep pessimism of courts who haven't stood up on issues of economic equality, courts that haven't stood up to forms of, but one of the things I caught was the courts not standing up to discrimination unless it's done by state governments, as opposed to private citizens or other groups. So this is making me think we've got real vulnerabilities on the legal front. So what is your vision for fighting for equal justice for all? If I'm assuming that with our current Supreme Court, you've got to feel somewhat pessimistic about the courts as being the avenue for change, at least in the immediate future. So where and how do you see us moving this agenda forward?
Well, I do think it's unwise to rely too extensively on the courts as an avenue of change, particularly the current composition of the court. I think it'll be good on some issues, but not good on a lot of others. And especially, I don't see it as a barrier to these movements to engage in vote suppression, because unfortunately, the Constitution does allocate the states extensive power over structuring elections. And so while there are strong contrary legal arguments, there are also ways that constitutional conservatives can defer to the states on a lot of these vote suppression activities. But I also think in general, in a system of democratic self-governance, it isn't good to rely too extensively on the courts. It is much better to rely on civic activism of a wide variety of sorts that include social movements, that include protests, that also include participating in electoral politics. And one point that Heaster made earlier, I think is tremendously significant. We are seeing lots of laws that I regard as abhorrent to make it harder for people to vote, and particularly people of color, and poor people more generally. But it's also true that these laws aren't necessarily all that effective. They can be overcome through voter activism and voter turnout. And then if you win the election, you can restructure the election laws again. You can create independent districting commissions, as they've done in Michigan and other states. You can get power through democratic processes, which actually, in the long run, is more reliable than simply writing something in the Constitution that can be interpreted by different courts at different times. If you can build strong democratic majorities in favor of inclusive policies, then that legislation is likely to be more enduring, and you'll also be in a position to appoint a lot of the judges on the federal level, so they're going to be interpreted favorably. I believe fundamentally in processes of democratic change. I know that that's terribly difficult now because we are as divided in our country as we have been since the horrible period of the Civil War. But I do think that if you look at the trajectory of American politics over the last couple decades, you see great dangers, but you also see great opportunities for success. And we as citizens can seize those opportunities and make them real.
So here's a question. In the past, we've seen how the movements for racial justice, women's equality, and LGBTQ justice have all been pitted against each other, and how each movement was weakened as a result. This is in the distant past, not the recent past. In a time when identity politics seems to becoming even stronger, perhaps in part due to our present political dysfunction, do you all see particular frameworks that might help people to work together for the good of all? Now, I realize that's a little confusing question because the first three things no longer are necessarily where the divides are. But I'm just wondering about frameworks that you see. It seems like we're needing pretty radical change in this country, given our history. And I'm wondering where you're looking to for the frameworks that can help us overcome the kinds of divisions we're confronting right now to move people forward.
Reverend Summers, one of the things I said earlier was that we should do a better job of building relationships and building friendships before we need them. If you really dissect what happened in America and across the country, and across this world during the Black Lives Matter protests, there were as many young whites as there were blacks. There were as many gay and Hispanics and people of all stripes and colors and persuasions on the front lines. In some communities, it was all white people with Black Lives Matter. I am saying that's a different America than the America many of us may have grown up. I'm saying some of the change that we want to see has already happened, and it is happening. Young people, I'm not that cool anymore. I've aged out of coolness. But I'm impressed with young whites who know every word to a hip hop song because their paradigm, their worldview is radically different. People genuinely like each other. My wife and I went to South Beach not long ago, and man, first of all, South Beach is really for like 20 and 30 somethings. And I just saw people who were just loving each other and having a wonderful experience. So when I say that I think we're closer than we think, I recognize we watch too much news. I'm about to graduate out of watching news because it took me a bunch of years to learn, when things get real bad, somebody's going to tell you. You really don't have to program yourself with all that negative over and over and over again. So my point is, I think that things have changed. I think things are changing. I think the Civil Rights Act of 1964 and the Voting Rights Act of 1965, the Fair Housing Act of 1968, the Community Reinvestment Act of 1975, I think all those laws did matter, and they did usher in a new era. I do agree with something Professor Smith said earlier. Not only do many of our laws need to be extended and defended, that's just the nature of the political cycle. We need to review where we are, what progress have we made, and the things that we need to tweak. That's the nature of the public policy process.
And I think with regards to the LGBT community, there's a great deal of intersectionality in the community. It's not solely white, cisgender, male, wealthy,
That's exactly right.
which I think is a perception in the media. We're diverse in terms of race. Economically, there are more LGBT families living in poverty in compared to heterosexual families. So issues involving racial justice, that's an LGBT civil rights issue.
That's
issues
exactly right.
involving immigration, economic justice,
Yes,
all
sir.
those voting rights, they all have an impact. And so it's so important for the LGBT community because all these things do impact the community. So it's not solely, related to things focusing on sexual orientation and gender identity.
Yeah, you said something earlier too, Jay, that I thought was especially significant. What I mean by that is very often we allow people to marginalize us with certain labels. LGBT is not all about sodomy or sex. And the same way I've watched over the years, we racialize and thus marginalize. What I mean by that, if I say immigration, which you referenced earlier, do we think of a particular race? Immigration is an issue to all of us. I don't think any of us were born here. Most of us are related to somebody that immigrated or migrated over here. If I say terrorism, is there a particular racial group that comes to your mind? So we racialize and we thus marginalize. If I say poverty, many people think of Black people. Most people don't know that 2 out of every 3 people that live at or below the poverty level in the United States of America are white. But we've racialized it to think that it's a Black people problem. If I say crime or criminals, very often in the American conversation, we think of Black people or people of color. The fact is, African Americans are some 14% of the population. And guess what? If you look deep, and I know our professor probably has these statistics, Black people do almost exactly 14% of the crime in America and almost exactly 15% of the drugs. We do obviously a little more drugs than we do crime. But my point is, the number 1 crime in America is, guess what? Drunk driving. 85% of the culprits are white males. If jails and prisons were a reflection of criminal activity, jails and prisons would be filled with white males. The fact that jails and prisons continue to fill up with Black males and now Black females, that's really more of a reflection of police activity than criminal activity. Part of the conversation you're hearing about reimagining policing has everything to do with that kind of disparity. I won't use the expression defund the police, because God knows I like police. I'm related to a bunch of them. There's a couple of them I don't like. They're jerks, but that's not unique to being a police. Being a jerk is not unique to being a police. But I do think in Detroit now, we've got a new police chief that says he's going to put social workers and mental health specialists in patrol cars, particularly when they know that the call has to do with a mental health disease. That's reimagining policing. You follow me? It's a new era. There is no subject that's so sacred that we cannot have a discussion about it. But when I said commit to anti-racism, when people racialize and thus marginalize, all of us have an obligation to speak up.
I'd add that on the question of how we build coalitions for change, it is both absolutely true, as Jay and Heaster have stressed, that if you look at the social movements today, they're more inclusive, more intersectional, they're pursuing more broad-ranging agendas than in the past, and I think this is enormously promising. We also need to recognize that many of the most alienated Americans now that are suffering what we call deaths of despair from drug use, alcoholism, suicide. These are often poor white Americans,
Yes,
often
sir.
rural white Americans. And I think progressive coalition, a coalition that can build support for a project of extending rights to all, has to make an effort to show concern and reach out and include these Americans who are also suffering. There is a tendency to demonize them. A lot of them didn't vote the way I voted, but I think it's challenging, but there is an opportunity if we show real concern for people in distress that we can bring them into our beloved community, Joe.
Yeah, and Professor Smith, you said something earlier, which in my history understanding really speaks to like the Southern strategy that certain conservatives use, where very often whites think that Blacks are getting, poor whites in particular, or working class whites think that Blacks are getting something that they deserved or something, or taking something away from them, when in fact, we're in the same boat. The only thing worse than being poor is not knowing that you're poor. The only thing worse than needing healthcare is not knowing that you need healthcare. And if you really want to have a little session in comedy, go on YouTube and find a couple of those little 4-minute interviews with poor white people who have no teeth speaking against Obamacare, just because it was a Black guy who was. I mean, people vote against their own self-interest if you racialize the issue, and that's unfortunate.
Yeah.
We would like to give each of the panelists time for their final comments, and there is, in order to do that, there was a question that popped up in the chat, and I think this is a really great question to go out on. And this was from Audrey Anderson. She said, many are expressing fear about what is happening in America. What thoughts do you have about where America is heading if things do not change? So you can respond to that as well as give your closing comments. So let's begin with Jay, then we'll go with Heaster, and then we'll go with Rogers.
Sure. Well, thank you for that question, Audrey. You know, I'll be honest with you. I sometimes feel fear too. I look at some of these things today. I watched the hearing yesterday, from the police officers at the Capitol, and it was just so saddening of what happened. And then, of course, you hear the response from certain elected officials still denying that there was any insurrection at the Capitol, and the fact that some people will deny actual facts and reality. But I also have a great deal of hope because, like Heaster, I really do believe in the younger generation and their ability. I think in terms of their acceptance of differences within their own age community, I think that's very hopeful. I think the fact that that in terms of the election results, that despite all the things that have been going on, that that President Trump, for my own self-belief that he wasn't reelected, I think that's a sign of hope. I think there's a lot of people, obviously, as a result of elections, who do share some of the same values. And the fact that you're here tonight and we're talking about these issues. So I really do believe that of course, there are always people who have ideas and thoughts that go against all the principles of democracy and fairness and dignity that I believe in. But I also know that there are a lot of other people out there that do feel the same way. And I do think we can make a difference. And Rogers, I was heartened by what you said in terms of even with these restrictive election laws, that there are ways that we can still get people to participate and to get them out to vote. And I know that that's what I'm committed to do, no matter what happens, with this legislation. So I remain hopeful.
And thank you, Jay Kaplan. I too am hopeful. Two quick things. One of the most significant lessons I learned as executive director of the NAACP Detroit branch was that the best way to get people to come to your stuff is to go to their stuff. You follow me? The people who showed up the most were the people whose initiatives we supported. So I'm just, that's a little bit of advice to organizers. Show up for other people's stuff; they'll come to yours. And I'm at a unique place in my life experience where I think it's healthy to disagree. In fact, I like people who disagree with me if they can defend their position. And in fact, you have the right to disagree. And even more important, you have the right to be wrong. And usually if you disagree with me, you probably are wrong. No, I'm just teasing. But I am encouraged. I think America's best days are ahead of us. And I would simply conclude by saying very special thank. Nice to meet you, Professor Roger Smith, Reverend Summers, and Reverend Roland. Thank you guys, and Kelly and Debbie Dingell. But I believe if we want our children to enjoy all of the benefits of the sunshine, we have an extra obligation to walk in the light. Thank you for having me.
I want to join in thanking all the panelists, but all the participants who raised such important points. On Audrey's concern about where we're headed, when she posted that initially, it was in the form of what happens if things don't change? And if things don't change, the future is pretty grim. I think we have to acknowledge we are deeply divided as a nation, and we're not taking action on enormously significant problems. Our racial and economic inequalities, our other social injustices, but also climate change and the need for the investment in the infrastructure that can provide for our future and much else. And we're not making progress in the halls of Congress these days at nearly as much as we need to do. And yet it's also true that we all share an interest in addressing the danger of national decline. We have seen, if you think back over the experience of the pandemic, an extraordinary new will to take governmental action that, even if it's insufficient in many respects, involve far greater expenditures to provide for health and stimulate the economy than were even imaginable. It used to, Barack Obama thought he had to keep his recovery bill under $1 billion. Now we have spent trillions of dollars. Things have changed. And it is also true that while we are deeply divided, one party has won the popular vote in every national election except one since 2020, since 2000 to 2020. The Republicans have only won the national presidential vote once. The Democrats have won the popular vote every time from 2000, except for George W. Bush's reelection. What that shows is, I think, that we can trust American democracy. We do have to take action to mobilize, to build coalitions, to reach out to those who disagree with us, as Heaster was just stressing. But the notion that we can't come together sufficiently to make progress on our problems is belied not only by our national history, but by our recent history. We do need to take these challenges seriously. We need to have the kinds of discussions that we're having tonight. And then we need to get out and engage actively in the processes of change. But it is within our power to build the better future that Jay and Heaster both are stressing is very possible.
Thank you. Reverend Joe, you're going to have the parting words, but before you do, I would just want to say thank you to all of our sponsors for tonight's forum. That is Inclusive Justice, the Center for LGBTQ and Gender Studies in Religion, that is on the Pacific School of Religion campus, and the Episcopal Church of the Incarnation, Metropolitan Community Church of Detroit, the Gender Identity Alliance, and the Michigan Unitarian Universalist Social Justice Network. We have many of our participants. We want to say thank you to each of you as well. We have quite a few from Southeast Michigan, but also all the way up in the Upper Peninsula and on the west side of the state as well. We have participants tonight from outside of the state of Michigan, and we're so very grateful for your participation tonight. I'm going to allow Reverend Joe to give thanks to our panelists along with his parting comments.
So I guess, so first of all, you know, it's so encouraging to have people thinking as clearly as our speakers were thinking and presenting tonight. Just very, very helpful. So thank you all for taking the time of effort. I know you're all extremely busy people, so just so grateful to all of you, from all of us. And I guess I'd just like to leave with I've been part of the Poor People's Campaign the last 2 or 3 years, and just in with this vision that the Poor People's Campaign has held up, and that it's time for a third Reconstruction. That the first Reconstruction is the Reconstruction movement. That the 14th Amendment came out of. The second Reconstruction movement was the era of the Civil Rights movement. But now it's time for a fundamental renegotiating of how things work in our country in terms of racial and economic discrimination, and this whole power structure and system that seems to continue to promote the opposite of the kinds of democratic values and vision that we've been talking about tonight. So my hope, you know, is that we can take seriously this call to be a rainbow coalition and to fight for the kind of world we want for ourselves and our children and our grandchildren. So thank you all so much. Good night, all.